Welcome.
Thank you. Thank you, Chairman Nass, Vice Chair Weingard, and distinguished members of this committee. I wish to thank you for holding today's hearing on Senate Bill 275 and for providing an opportunity to hear my testimony on the proposed legislation. My name is Daryl Modine. I reside in Muskego, Wisconsin, and I speak to you today not only as a business owner who serves customers in all 50 states of our great republic, as well as 9 countries around the world, but I also speak to you as a representative for the League of United Latin American Citizens, or LULAC, of Wisconsin, our nation's oldest and largest Hispanic membership-based organization. I'm proud to say here in Wisconsin, LULAC has opened and operates a community technology center where individuals learn important job skills, can apply for jobs online, and much more. We've donated nearly 100,000 pounds of meat with our partners at Tyson Food to help Wisconsin families that suffer from food insecurity. We've provided over $1.4 million in college scholarships to deserving and talented Wisconsin Hispanic American youth. We've provided over $500,000 in online reading intervention software to both public and private schools in need, and we've spent over $450,000 in dual enrollment programs where we take individuals out of some of Wisconsin's most challenged high schools and we help them transition to college at a rate of over 99%. In addition to all that, my company, we're very fortunate to have donated over $850,000 in wireless LAN equipment and services, or Wi-Fi equipment, to schools in need. And I share this not to boast about our accomplishments, but to underscore LULAC's commitment to Wisconsin and to being problem solvers, not just simply people who point out issues in the community. We're able to do this because we have strong partnerships with organizations such as Ford, General Motors, Toyota, Walmart, Target, Walgreens. The list goes on. And I'm proud to say 99% of everything I just said here was paid for either by LULAC or through our private partnerships. Not a cent came from public funds. LULAC was founded on the guiding principle of helping Hispanics integrate into the American cultural fabric. Much of our Constitution is in fact based on the U.S. Constitution. The LULAC prayer is an adaptation of Thomas Jefferson's prayer for a nation. Our flag is indeed the American flag, and our song is America the Beautiful. Hispanics continue to make rich cultural contributions to society and are beginning to drive more of our state economy right here in Wisconsin as Wisconsin's median workforce age continues to climb. Given recent workforce statistics found in numerous studies, and now with the signing of the agreement with Foxconn, it's more urgent now than ever that Wisconsin do everything it can to attract workers who are entrepreneurial and young and motivated to our state. Since our inception in 1929, LULAC has fought hard to defend our nation on foreign battlefields as well as at home in the courts when necessary, never asking for something given, but always insisting on our constitutional right to an equal opportunity to achieve the American dream. This brings me today to Wisconsin Senate Bill 275. While LULAC firmly believes that every sovereign nation has the responsibility to protect its borders and that each branch of government has its exclusive rights, and that we must vigorously defend each right in the Constitution, not just a select few, so must we respect the jurisdictions and authorities defined within the sacred document. LULAC is committed to the defense of the U.S. Constitution and those it serves. After careful review of Wisconsin Senate Bill 275, LULAC and LULAC of Wisconsin have found that it has striking similarities to Texas Bill SB 4. Both Texas SB 4 and Wisconsin SB 275 seek to prohibit ordinances, resolutions, or policies that prohibit the enforcement of federal or state law relating to undocumented immigrants, as well as inquiring as to an individual's immigration status. They both require compliance with detainer requests from Immigration and Customs Enforcement, ICE, and they both seek to impose financial penalties on government entities that do not comply. In addition, they both seek to force liability on those governing bodies for damages found to be caused by undocumented immigrants. As I'm sure you are aware, LULAC with the city of El Encino, the ACLU, and our sister organization here at the Mexican American Legal Defense and Education Fund, or MALDEF, are currently in litigation with the state of Texas. As with SB 4, our analysis, as well as the findings of U.S. Chief District Judge Garcia, who heard our complaint in Texas, found numerous constitutional issues with these provisions. Due to the limited time I'm afforded here today and the numerous issues and the complexities of those provisions, I've included a copy of the judge's order in Section 2 of my written testimony. So if you flip to Section 2 of the handout provided, you'll find that order. I would also be remiss as a resident of the great state of Wisconsin if I did not at least mention additional litigation applicable to SB 275 regarding financial penalties. I believe, Senator Wertz, you referred to this earlier. Earlier this year, in the County of Santa Clara and City and County of San Francisco v. Donald J. Trump, a nationwide injunction was placed upon that executive order, 13768, titled Enhancing Public Safety in the Interior of the United States. This executive order purports to ensure the jurisdictions that fail to comply with applicable federal law do not receive federal funds except as mandated by the law. This was found by George Orrick to have numerous constitutional issues as well, and as I stated earlier, this executive action is under nationwide injunction. Once again, due to time constraints, I did include a copy of Judge Orrick's finding in Section 3 of the handout that I provided. I've also included in Section 4 of my written remarks, legal clarification as to the nature of detainer requests from Immigration Customs Enforcement, ICE. It is important to note that detainer requests are not court orders. Saying that failing to adhere to a detainer request is breaking federal law is incorrect. ICE has at every step of the way the ability to go and request a court order asking that municipality, county, or subdivision to hold an individual. There is not a high threshold to issue a detainer from ICE. So let's get that clarified here. It is a voluntary action, and you'll find that right there on the ICE website too, if you want to go and take a look. In closing, I'd like to add that not only does SB 275 have numerous constitutional issues, but above and beyond, our analysis has shown that it is simply not in the public interest. As a state, we pride ourselves on fair play, on helping our neighbors, on the benefits of working hard to provide for our families, and in times of need, lending a helping hand. SB 275 would send a message of fear and division and would have a chilling effect on police-community relations, as well as have a disproportionate and discriminatory impact on individuals with prominent Hispanic features. As we all seek what is best for our state, do we not want each and every person to feel comfortable in reporting a crime they've witnessed or may be in progress? Is it not in our interest to have people feel comfortable in calling the police or the fire department if they're witnessing a medical emergency or a fire that's occurring? Is it not in the public interest for a woman or child who may be suffering from domestic abuse to be able to call the police and feel comfortable in doing so? While there are some who say SB 275 is designed to keep us safe, it will in fact have an opposite and chilling effect. I could continue, but once again, I'll simply say that LULAC and LULAC of Wisconsin, for our constitutional reasons so defined in my written testimony and reference, as well as our concerns for the public interest, we cannot support SB 275. Once again, distinguished gentle ladies and gentlemen, I appreciate your time and your serious consideration of my remarks on the proposed bill. May the Lord bless all of you. May the Lord bless the great state of Wisconsin, and may the Lord continue to bless the great country that is the United States of America. Thank you.
Thank you, Mr. Chairman and distinguished senators. My name is Stephen Monroy, and I'm here representing MALDEF. I'm a legislative staff attorney with MALDEF, the Mexican American Legal Defense and Educational Fund. MALDEF is the nation's leading Latino legal civil rights organization, promoting social change through advocacy and litigation. Since its inception nearly 50 years ago, MALDEF has made significant contributions in securing the rights of Latinos in the areas of education, employment, political access, and immigrants' rights at both the state and federal levels. Currently, MALDEF represents the city of San Antonio, the city of El Paso, and various local officials in various cities and counties challenging the implementation of Texas Senate Bill 4. I am here today to ask that you vote against Senate Bill 275 because it raises serious constitutional questions and it is wrong public policy. It puts local governments and the state of Wisconsin at risk of litigation, and most importantly, it prevents local governments from being able to make policies that are the best fit for the needs of their communities. The enactment of Senate Bill 275 would violate the principles of federalism and lead to arrests that violate the 4th and 14th Amendments of the United States Constitution. Senate Bill 275 requires local governments comply with, quote, any lawful detainer issued by U.S. Immigration and Customs Enforcement. In effect, Wisconsin is creating its own immigration policy. Senate Bill 275 makes it likely that local law enforcement will be compelled to make arrests or prolong detention longer than allowed under state criminal law, and longer than allowed under the U.S. Constitution. Under the Constitution, law enforcement must have a warrant or probable cause of a new offense to detain a person longer than they would otherwise be released. And under the Constitution, U.S. immigration and federal customs enforcement cannot order state and local law enforcement officials to arrest persons that they suspect are undocumented. The 10th Amendment prohibits the federal government from commandeering state resources to enforce federal law or federal policy. And more than that, the enforcement of requiring local governments to enforce detainers would force the state to assume the financial cost and the risk of litigation that are on the federal government. And this is especially important since the federal regulations themselves prohibit the Department of Homeland Security from reimbursing the cost of detaining a person until ICE assumes custody. So in fact, the local jurisdiction, the local jail, will be assuming all of the cost of detaining a person longer than they would have posted bail or otherwise been released under local law. And as my colleague from LULAC had mentioned earlier, these detainers are just requests. They are not the equivalent to a judicial warrant signed by a judge. They do not have the force of law, and there's not necessarily probable cause behind it. So local law enforcement should not, and in most cases, do not choose to use that as a reason to detain person under probable cause. For these, SB 275 would prevent many jurisdictions from adopting reasonable ordinances, resolutions, and policies that protect their residents from unlawful arrest and themselves from litigation. For these reasons, MALDEF urges you to vote no on Senate Bill 275 so that local governments can determine for themselves and choose their own policies, and so that the state does not spend valuable resources detaining persons longer than allowable under Wisconsin state criminal law. Thank you.
Thank you. We disagree on a number of fronts, but in the essence of time, the case that was mentioned in Texas is on appeal, as I'm
Correct.
sure you know.
Correct.
So we'll see where it goes. That's why we have the courts to be the referees, whether it would be this legislation or in the state of Texas.
Correct. We
Or
expect
elsewhere.
that to be November 7th, so.
Okay. So how do you wrestle with, because this bill deals with the criminal element, period. The case I mentioned previously, Sanctuary City, where they did not cooperate with ICE to the detriment and the life of another person. There's just so many of these. Teresa Tranchant, 16, killed. She was rear-ended. And the person had a prior history of convictions, but due to the Sanctuary City status, was ICE was not notified. So we got it out to kill again. So how do you?
So I guess I'll go first, and we haven't had a chance to discuss this, so I'll just be answering for myself and,
Yeah.
and for LULAC of Wisconsin. I think there are issues that must be addressed. I don't know anybody who can justify such a thing happening. ICE does have at their disposal the ability to go and get a warrant so that somebody is arrested to force that to happen. I will say, though, at the end of the day, sadly, we continue to wrestle with symptoms of what we all know is a chronic problem with regards to immigration policy as a whole. And that is why it is Congress's purview to go ahead and get this resolved. I can share with you that we've been working extensively with Speaker Ryan's office and leadership on the other side of the aisle. We actually have great expectations, we do, and I speak only for ourselves, that this is finally going to be addressed. But I believe that this legislation is overreach into an area where really there isn't the purview here. Do I wish that those tragedies would have been and could have been avoided? Yes. Were there tools in place that could have been used, that could have addressed the situation? Yes. But at the end of the day, I think we know that there is a larger problem going on here that does need to be addressed by Congress. And I'll simply add this, and as the last part of my statement before I turn it over to my colleague here, is that it has been proven over and over again by nonpartisan independent bodies that it's statistically safer to leave in an immigrant neighborhood than not. So we are not very concerned these days with some of the rhetorics that's being used. It makes all undocumented individuals look like they're murderers, drug dealers, and rapists. That is simply not borne true from the fact. So I just wanted to get that on record. I would also suggest that when we looking at facts with regards to this issue, that you look at organizations that don't have a reputation for being extreme and look to organizations that are in fact nonpartisan and independent by which to quote fact, because I can share with you some of the studies that you referenced. There has been issues found with their methodology in coming to those conclusions. So, thank
Well, the broad brush aspect, I would agree. That's why I was very clear. This deals with people who have killed other people, who have raped, robbed. So the other illegals out there that have obeyed the law, Bill doesn't deal with them. These are people who are just bad people. Whether they are illegal or if there are bad people who are legal, I don't want them out on the street.
And I'll just simply add that there are mechanisms in place by which to address that, and there really would be no cause for the state to enter into that.
Well, we disagree because in a number of these, and it is lengthy, whatever you're referring to has not worked in too many cases. Go ahead, sorry.
Thank you, Mr. Senator. I would fully agree with all the statements that my colleague just made. And I would add that I think that we're all in agreement that the state criminal law should be enforced against people who violate state criminal law. However, it is a dangerous precedent when we suspend the Constitution to say that this policy that we're trying to push is something that could have an effect of protecting public safety, but it actually really goes down to actually making us all much more vulnerable to government action. So the Constitution is very clear for a while, or for a long time now, that the separation of the state and federal functions are such because the state can make policy choices for itself dealing with state issues, so state regulation, state criminal law, whereas federal immigration policy is something best left to the federal government. Now, there are certain things that the state can do and interact with the federal government, and that perhaps is a discussion for another time. But this here is not narrowly tailored to really meet those requirements of what the courts have said for a while. With the U.S. v. Arizona case, where Arizona was trying to create its own crime of immigration on the state level, the courts found that no, that was the prerogative of the federal government. And at the same time, the courts have made it clear that these detainers are not something that can be imposed upon the state. So there are many possible policy issues that can do to increase public safety, but a broad stroke change to require local law enforcement to follow something that does not meet the probable cause requirements really makes a lot of harm to public safety. So that's just essentially what my topic would be, is that the Constitution is quite clear about what these different policy options are, and we have to be very aware of not breaking the Constitution. Thank you.
Questions, committee members? Senator?
Well, the only thing that I would like to just maybe make just a note here of is that, as I recall, when I was sworn to be a law enforcement officer, which I did for 30 years, I swore to uphold the United States Constitution and all of its laws, and the state Constitution and all of its laws, and assisted many arrests that were federal fugitives. As a matter of fact, the fatality or the injury accident that ended my career was with a federal fugitive. So to separate it out as easily as you have here, it really doesn't work, and illegal is illegal. We are focusing on one portion of those violent criminals, and not all of the individuals that are here illegally. They're not immigrants, they're illegal aliens because they're here illegally from that standpoint. There needs to be a process, I totally agree, and there needs to be something happening at the federal level, totally agree, and hopefully you're gonna get something done with that. And I understand that, but we are looking at a situation that's occurring where if we look the other way, for individuals that are repeat violent criminals, it makes absolutely no sense to continue to allow that repeat violent criminal to continue to do what they are doing and not deal with that issue. And that's what this legislation is trying to do. And that's where I see that it creates more of a problem, simply because what becomes the focus of a person that is here illegally? It's the focus of these bad guys, because those are the ones that are on the 10 o'clock news. So everybody that maybe came here for a better life, all of a sudden is drawn into that perception. And it's not accurate. You know, it may be a small percentage, and that's the percentage that this legislation is focusing on. And I would think that every person that is here should be supportive of getting rid of these bad guys, no matter where they're from. And they're not all coming from Mexico. They're coming from all over the globe that we're having these issues. So, I mean, that being said, I would hope that you guys would help to resolve that issue and that we get rid of these bad guys, because that's what's making it difficult to resolve the other issues with people that are here just trying to make a better life for their family and are trying to be good people.
May I respond?
Sure.
Absolutely.
So, no, I welcome that question. It's an excellent question, and I can at least just speak for ourselves. I think everybody who is a victim of a violent crime or sell drugs to kids, et cetera, given due process, doesn't need to be given the ability or protected to stay here, et cetera. But to your point, I think, once again, existing mechanisms are in place to address those issues. You also made a statement where, you know, illegal is illegal. And it's interesting. For someone who comes to this country and overstays their visa, they have not created, they haven't committed a crime. It's an administrative issue. It's not a crime to come and overstay your visa and stay here. That's how broken the system is. If you cross the border without inspection, that is a crime. Interestingly enough, what is a crime too is if you're undocumented and you're here and you're not paying taxes, that's a crime. Any one of you could call the IRS today and ask and say, I have a friend who's undocumented. How would they pay their taxes? They will walk you through the process, and just so you know, by the time you get to the end, you're going to find out they often pay a higher tax rate. So that really underscores how broken the system is. If you turn 18 and you're undocumented in this country, you still have to register for the Selective Service. And that's why millions of individuals have. Many serve in the U.S. military, et cetera. So we do have a broken system here. But that needs to get fixed, and that is the purview of Congress.
Totally agree. There's been a lot of enabling things that have made this worse. I totally agree.
Right.
And that's why this focus of this is to deal with just that element that is so egregious that we don't want it to be repeated over and over. I mean, what can I say? Yes. Go ahead.
Thank you, Mr. Senator. One thing I'd be remiss if I hadn't mentioned is that it's not just people who are later on found out to be undocumented that are detained pursuant to these detention requests. It's also been very common for U.S. citizens to be detained, and if a U.S. citizen is detained even just 6 hours while they check, you know, that's a violation of their civil liberties, and that is something that's actionable against the jail, against the arresting officer, against the state. So it does put this increasing risk of litigation, whereas the federal government has nothing to lose by issuing this piece of paper saying, we'd like you to do this, but it puts the onus on the state that they're penalized if they don't follow the request under this Senate bill, or they are penalized later on if they do follow it and found out that they're holding somebody without probable cause.
But if they do issue that detention, then they're held harmless if they do hold them,
Yes,
correct?
but not under the federal law.
Well, they could
the Constitution.
obviously go after the federal government for issuing it if it wasn't issued properly.
I-
But it still holds the jurisdiction harmless, the way I understood the law.
I think we would have to see how the courts would interpret that to see if they would suspend the Fourth Amendment for that.
Thank you.
Well, in this bill, getting at the criminal element, that is the element that makes everybody look bad. And that's what the bill clearly is getting at. And someone that overstayed their visa, in this lengthy list, there's another one in 2015, overstayed the visa. A person had a protection order, and she ended up getting killed. Senator Wirch.
Well, let me make it crystal clear. Just because we have problems with this bill doesn't mean we're protecting criminals. Let's get that real clear, okay? Number one. Number two, we wasted enough money in this state on legal challenges. I think it's about $10 million on the gerrymandering case. Why don't you wait and see what happens to the similar bill in Texas? that is being challenged on constitutional grounds. We've wasted enough money on lawyers in this state. Let Texas pay for it, and then we'll learn from them. Thank you.
Senator?
Thank you, Mr. Chairman. Quick question. You said there are existing mechanisms in place already to deal with these particular people who are criminals. Should that be binding, or is it binding to cover what this bill proposes to do
ICE
the
is
same
free
thing?
at any time to avail themselves to go and get a warrant to detain somebody. A detainer is a voluntary request which has no weight of the law or the courts behind it. And just to let you know, and I appreciate, Senator Wirtz, your statements too, or your comments, just to let you know the depth of the questions that are here in this legislation. A similar bill, once again in Texas as before, is being challenged for violation of the Federal Supremacy Clause, Amendment 1, 4, 9, 10, and 14, and I know there's a few more that I can't remember. But this is a pretty large, what I would say, overreach into federal authority, but this will be settled by the courts. We're expecting the appeal to be heard November 7th, and ultimately, though, we think it's going to go all the way to the Supreme Court. So it's going to be a very costly endeavor for all.
Follow up, if I may?
Yes.
Okay, thank you. The challenges in the courts, as Senator Wirtz mentioned, are exorbitant, and that's just another fee that I don't think we need to support. But I'd also mentioned earlier the ability of local police departments to oversee some of this. And then you also alluded to the fact that they would bear the cost if they have to hold someone longer than the normal time. So indeed, it would be a cost to local municipalities or county sheriff's departments who are charged with holding those people, processing complaints. Is that correct?
Correct.
Okay, thank you.
Any other questions?
Oh, go ahead.
No, I was just going to say, any other questions?
Just a comment. You mentioned ICE has the ability to go and get someone. But if they don't, in the sanctuary cities, if they don't know they're being held, how can they go get them? And that's the key to this. Just communicate, and ICE may say, no, we're not interested. We're not interested. But if they don't know they're there, they're not able to go get the person. And regarding the litigation, and we'll see where Texas goes and whether this gets litigated, that does not scare me at all. We had litigation here, when you talk about spending money, that the opposition went after, and that was Act 10, litigated heavily. Prevailing wage was litigated heavily. Right to work, litigated. All three of those are the law of the land here in Wisconsin. So I guess we'll just see what happens. Go ahead.
Mr. Chair, just wanted to clarify something. When somebody is arrested, they're fingerprinted, and that goes to the federal government through the FBI database. So ICE is aware of every person who is arrested and has had some kind of contact with the police. So ICE could then go and follow up, and there is nothing in most of these different welcoming ordinances or any other kind of that would prohibit that kind of communication. What it does prohibit is that onus on the police department to wait until they get the okay from ICE to release somebody longer than they would under state criminal law.
Well, I'm not going to belabor we have other people to speak, but thank you very much.
Thank you.
Thank you.
for coming to testify.